Sometimes in employment situations, you might have an employee who lives on premises. It could be a home health care worker. It could be somebody who works, for example, in a building, an apartment building, and acts as a superintendent or as a laborer in the building. And they're provided in exchange for services rendered room and board. That might be the form of an apartment that's rent-free. It might be in the form of a bedroom in a home in which you're taking care of elderly clients. It could be in the form of also providing meals. It could be in the form of part-time or full-time live-in status. And yes, there are provisions in the law which allow the employer to count that provision of room and board as part of the employee's wage. And what you need to be very careful of in these situations is that the minimum wage laws still apply, even though that room and board is being provided as part of the wage. You must be very careful to document and keep track of exactly how much that room and board is taking in terms of a deduction against that employee's regular wage. And you need to, at the end of the day, also make sure that even though the person is living on the premises, they are not working every hour of every day. Keeping track of employee time is very critical, especially in these live-in situations, because oftentimes employees will later leave the company or leave the employment situation, leave the employer, and you find out that they're now claiming that they worked around the clock, or that they were woken up extra early to perform a particular task, or 9 times out of 10 they worked 60 hours a week, not 40 hours a week. And that's where the problems arise. And so even though you may have provided them with free room and board, and you deducted that from their minimum wage, or their hourly wage, I should say, so that you still make the minimum wage, they're now saying that they worked extra hours. And so that pay doesn't necessarily amount to proper pay under either New York State or federal law.